Perfect. So we're going to get started our revocation hearing.
Morning, Chris. Can you hear me?
Yes,
hear you.
yes, Matthew. Mr. Maddox.
Perfect. So we're going to get started in 1 minute, okay? I just have to wait till it's 9 o'clock.
I can't hear Chris, but can anybody else hear me?
I can hear you, Matt. I can hear you, Matthew Maddox. I can hear you.
Hi, Chris. I just can't hear. I don't know why.
I don't know.
Does he need to restart? Does he need to restart? He can't hear you.
Is everybody else muted, or are my speakers not working?
I can hear you, Mr. Maddox. I can hear you. I can hear you. I can't hear you now. But...
He'll be right back. He has to restart to come back in.
Oh, all right. Okay.
So we'll get started as soon as he comes back, which is
All
right
right.
now. And hopefully this will fix the problem.
Good. Yes.
You can hear us now? I can hear
Yes.
you.
Thank you.
Okay, so we're going to get started with the revocation hearing. Perfect. I can see you too. Good morning. I am P.O. Meissner, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Ilchert Christopher, number 424677. Today is April 8th, 2025. This hearing is being conducted via video at the BOPP Central Office in Bridgeport Correctional Center. This is a public hearing, public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Matthew Christopher Ilkurt, 424677.
Thank you. We have a parole officer present. Can you please identify yourself for the record?
Parole Officer Boisvert from the Board of State here.
And we have counsel here today. Can you please identify yourself for the record?
Good morning, Matthew Maddox, the Maddox Law Firm for Christopher Ilkurt.
Thank you. This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which means releasing and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge, state your parole officer is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure?
No, I do not.
Okay. So your important rights today, your right to have an attorney present, you have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, I did.
Okay. You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses across the name and adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
All right. So we'll now review the charge. State your parole officer is bringing against you and information underlying each charge. So P.O. Boisvert, please read the charges.
Charge 1, obedience to the law. On April 25th, 2024, you were driving under the influence of alcohol and issued a citation by the Frederick County Sheriff's Department. On August 4th, 2024, you were found guilty of driving a vehicle under the influence of alcohol by the District Court of Frederick County and placed on 2 years probation. Charge 2, no consumption of alcoholic beverages. On April 25th, 2024, you consumed alcohol as evidenced by your citation by the Frederick County Sheriff's Department for driving a vehicle while under the influence of alcohol. On September 4th, 2024, you were found guilty of on that charge by the District County of Frederick, by the District Court of Frederick County.
Thank you. And the state has filed the following exhibits pre-marked for identification purposes as Exhibit A, signed statement of understanding and agreement, conditions of parole. B, special parole acknowledgement receipt. C, notice of parole violation. D, notice of parole rights. E, parole violation report. F, remand to extra custody order. G, 5324 progress report. H, citation court disposition. I, 82924 progress report. J, District Court of Maryland charge summary for case ending in 1572. Exhibit K is citation court disposition. L is this court disposition for 1572. M, ICOTS violation report requiring retaking. N is Maryland probable cause hearing paperwork. Did you receive notice of parole violation report, and those other documents I marked? And did you review those, sir?
Yes.
Right. Do you need to continue this hearing to obtain any additional evidence?
We are not making a request for continuance.
Okay, we have no witnesses today. At this time, the state will have an opportunity to call witnesses, present evidence, speak to any of the evidence submitted at this time. I'm going to swear in P.O. Boisvert as well as Mr. Ilchert in case you would like to speak today. Can you please raise your right hand? You solemnly swear, sincerely affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
Yes.
Okay, so P.O. Boisvert, would you like to say anything at this time?
Nothing additional other than what was submitted in the notice of parole.
So it's now defense's opportunity. If you'd like to speak to any of the evidence submitted at this time?
We would only like to be heard as to penalty, please.
Okay. So what I'm going to do next, then, I'm just going to announce my findings with respect to the charges. So on that charge 1, I do find you violated that condition, obedience to the law. This is based on your conviction of driving under the influence of alcohol and received a sentence of 2 years probation. Also based on exhibits I and J through M. On charge 2, I do find you violated condition, no consumption of alcoholic beverages. This is based on the evidence that was provided in support of that charge, which is exhibits J, K, L, and M. That includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose of this part of the hearing is to help determine what outcome I will recommend. So at this time, P.O. Boisvert, would you like to say anything?
Yes. As you noticed from the dates, there was a decent amount of time between when the violation was entered and when Mr. Ilkurt was taken into custody. We were notified that during that time he did participate in a substance abuse treatment program. So in light of that, I feel that my initial 6-month recommendation would be more appropriate to be reduced down to a 3-month recommendation, just in light of his behavior, good behavior following his conviction while on that period of probation while the warrant was out for his arrest. So I feel that 3 months is a more appropriate recommendation as opposed to the 6, obviously with any credit given for the time he was incarcerated in Maryland as well as his time incarcerated in Connecticut pending the hearing today.
Right. Thank you. I'll turn it over to counsel. Would you like to say anything at this time?
Yes, please. Thank you, Officer. Christopher did complete his treatment program in December. It's important for the Board of Paroles to know that Christopher has a Bachelor's of Science degree in engineering. That is his chosen field of employment. He and his family have relationships with companies that are prepared to listen to him about a potential employment application. I also want to be heard about where he will be required to reside upon his release. As Officer Boisvert knows, Christopher has been living in Maryland. He lives with his mother, who is aging. I think she's 76. Is that right, Christopher? Does not.
78.
78. Yeah, thank you. And Christopher is prepared to, if this can be approved upon release, enter a long-term alcohol rehabilitation program, which dovetails with the following request. My request is that he be remanded for no longer than 6 weeks and that he be permitted to discharge upon proof of admission to a bed in a facility in Maryland, near Frederick, Maryland, where he can receive inpatient treatment.
So he does not want to return to his mother's residence?
He does, but he, I think, in all humility, I think he recognizes that he requires some additional treatment. So I'm proposing something which would require him to be incarcerated for a lesser amount of time in favor of being in an inpatient rehabilitation facility.
Does he have a bed at an inpatient? Is he?
He does not, but we have been researching this since early last week. We are close to finding perhaps two facilities, but at least one that will inform us within the next 2 or 3 days of a bed and a specific date for his admission. He is still insured through Blue Cross Blue Shield.
Does he have other plans? Does he work, or is there any other release plans that he has?
He had been working. I think Officer Boisvert can confirm this. He'd been working for a company in Maryland as a machine operator for 2.5 years. He was discharged from that job once they discovered his DWI arrest, I think is what triggered his discharge from that. So I think probably since last September or October, he has not been working. He does wish to seek gainful employment, obviously.
Has he done outpatient programming before, or do you feel, or Mr. Ilchert, do you feel that inpatient is necessary, or do you feel like outpatient programming is more appropriate?
I believe it would be at the discretion of the counselor. Whatever they think I need. I just completed that.
Because I know you did programming before you went in. This is why I'm asking you if you would rather do outpatient programming and go live with your mother, or if you feel it's necessary to go to an inpatient program, although you already completed programming prior to coming back to Connecticut.
Yeah, I mean, outpatient and living with my mother, that sounds agreeable to me. That sounds okay with me. I mean, I'm not really addicted to any substances right now. I've been clean since the program.
That's my point, is you're clean. So going straight to an inpatient program, I don't know if it might be better if you can go back to your mother's, do outpatient programming and start working or finding employment.
That sounds favorable to me. That sounds favorable to me, to go back to my mother's house. This way I'll be able to help her, because she's 78 years old. She needs help with stuff around the house. She's getting old. That's all.
So may I just interject? So I'm not a clinician.
Right.
I've known Christopher for a very long time and his family. So that's why I began speaking about an inpatient placement, but he would defer to somebody with clinical credentials as to an appropriate recommendation.
Right. Usually we just don't place an inpatient when they're coming out of jail because they're clean.
I know.
So if it is determined, obviously he can go inpatient, but I'm trying to see what's the best plan. If you do return to Maryland to, live and where you were and work, and if that's what you choose, as well as do programming with that. I'm just trying to see what the best setup for you, knowing that you did complete programming prior to coming into the facility. P.O. Wizard, do you have something?
Yeah, I mean, in terms of going to Maryland with interstate, ideally, we can't do the interstate process until we have a location that he intends to go to. So in light of his willingness to go to treatment, potentially what we could look at would be to do a transfer to his mom's house and have the transfer request to Maryland include, an immediate evaluation and compliance with recommended treatment. That way, again, I'm not a counselor either. I'm not qualified to determine what level of care he needs, but I think a transfer back to Maryland, we are open to. And then once in Maryland, he could get evaluated, and if inpatient is recommended and Maryland approves that, we're great with that. If Maryland is okay with continuing an outpatient treatment that he was doing prior to his remand, we would be okay with that. So we would, I think, defer to the evaluation and recommended treatment.
You have the mother's address, all of her information.
Mr. Ilkurt, that you were living with your mother prior to returning to Connecticut?
Yes, I was living with my mother.
Okay, and it's your intention it would be that address to return to?
Yes, that's correct.
Okay, so yes, we have that in our system now.
Okay. So is that something you would like to do, sir?
Yes, that sounds favorable to me because she needs help around the house. You know, she has, you know, and,
Okay.
you know, if I did the math, I probably already have the 2 months in or whatever. So it would be a shorter time as well than having to go to the long-term outpatient. And, you know, considering I'm not on any drugs at the moment.
So Christopher, the answer is yes, right?
Yes, Matt.
Attaboy.
All right, yeah, I just want to make sure, I'm trying to set you up for what's going to be best for you, and getting evaluated when if you do go back there, sounds like it'd be a great, opportunity for you to get the treatment that you need. So is there anything else from either side before I make a recommendation?
Not for Mr. Ilchert, thank you.
Okay. So I'll be right with you in a second with my recommendations.
Thank you.
Thank you.
And I do want to put on the record, this is the offender's first violation of parole. He did receive no misconducts. There was a 3-month recommendation served by the parole officer. The offender was in the community for approximately 3 years and 6 months before being returned to custody. And he did receive 2 years probation for that driving under the influence. And he did participate in programming prior to returning to the state of Connecticut. Based on these factors, I am going to recommend that parole be revoked. You'd be re-paroled for May 12th, 2025. It's about a 3-month period of confinement as a sanction since your return to custody in Maryland. So I did take that a month into account and for your sanction. I recommend the following parole conditions: no consumption of alcoholic beverages, operation of a motor vehicle, behavior management program for anger management, mental health evaluation and treatment as deemed necessary, parole to another state, Maryland. I am putting halfway house placement on there just in the event that something does happen with the transfer, just in case. My findings will go to the parole board on April 17th. The board's going to review my written decision. The boards can lessen that sanction, let it stand, or impose a sanction longer than what I've recommended. If the board decides to impose a longer sanction than what I've recommended, you to have a supplemental hearing. And before that, the board would provide you with a written notice documenting the reason why they want to exceed my recommendation. During the supplemental hearing, you would have an opportunity to respond to those reasons while in front of the panel of the board. That is the event that they do disagree with me. So if they do agree with me, like I said, you will be released May 12th. Do you have any questions, sir?
No, I don't think so.
No. So I'm gonna put your mother's information back in for your sponsor in Maryland, and hopefully you will return there. Okay?
All right, thank you. Thank you for your time today. Thank you. Thank you.
Thank you, everybody.
Welcome. Have a good day, guys. You guys are all set.
Mr. Ilkurt, I'll be down in the next week or so to see you to sign your paperwork for the interstate process again. So I'll come see you next week or so.
Thank you, sir.
Great. Have a good day.
Thank you.
Thank you.
Bye, thank you.
Nice one. Thank you. Uh-oh, I see you.
You're all set. Thank you.
Thank you. Have a nice one.
regarding inmate Louis Alvarado, number 327279. The preliminary hearing has been waived by counsel, and a revocation hearing will be scheduled upon disposition of pending charges.
Good morning.
Good morning.
Mr. Reynolds is on his way down for you guys now, okay?
Thank you very much.
You got it.
Morning, sir. Mr. Reynolds?
Oh, I didn't see you. Good morning.
We're here. Good
I
morning.
didn't hear you. I didn't hear you say that again.
Can you hear me right now?
Yes,
Okay, good. So we're here for your revocation hearing today, okay? And I have your attorney here.
yes,
So,
ma'am.
so we're gonna get started, okay? P.O. Sullivan, can you hear me okay?
Yes.
Okay, so we're gonna begin.
Hi, Ms. Sullivan.
Hi, Mr. Reynolds.
How are you?
Good. How are you?
I'm bad. I'm good.
Okay. Good.
Good morning, I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Reynolds Victor number 119109. Today is April 8th, 2025. This hearing is being conducted via video at the BOPP Central Office, New Haven Correctional Center. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Yes, my name is Victor Arnett Reynolds, 119109.
Do we have a parole officer present today? Please identify yourself for the record.
Parole Officer Stephanie Sullivan.
And we have counsel here today. Please identify yourself.
Sure. Attorney Alfonzo, Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Reynolds.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better we your evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure, sir?
Do I have any questions you asked me?
Yes.
No,
Yeah.
ma'am.
Okay. You have important rights today, the right to have an attorney present, and you have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
You have a right to review the evidence against you. You have a right to submit evidence for to your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to move forward?
Yes, ma'am.
All right, so now review the charge the state your parole officer is bringing against you and the information underlying charge. So P.O. Sullivan, please read the charge.
Sure. Charge 1, obedience to the law. On 12/11/24, you were involved in a domestic altercation with your wife. The victim reported that during the altercation, you spit in her face, grabbed both of her wrists, and threw her on a bed in an attempt to grab her phone. Your actions caused bruising on the victim's wrist, broken mirror, and the bedroom was disheveled. Subsequently, you were charged with the following: CGS 53A-181, breach of peace in the second degree.
Thank you. And the state is filed the following exhibits that are pre-marked for identification purposes as Exhibit A, remanded custody; B, conditions of parole; C, notice of parole violation; D, parole violation report; E, Waterbury PD report ending in 8830. Did you receive notice of parole violation report, and those other documents I marked, and did you review them, sir?
Yes, ma'am.
Okay. And counsel has filed the following exhibits that are pre-marked for identification purposes as Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement, and Exhibit 2, which is student spotlight article. Do you need to continue this hearing to obtain any additional evidence?
No.
We have no witnesses. I do want to put on the record the addendum that we have received from PCS stated on 3/7/24, the offender was convicted of breach of peace second and received a 4-month jail sentence with an EUS date of 4/13/25 on that sentence. We have no witnesses today, so at this time, the state is going to have an opportunity to present evidence and speak to any of the evidence submitted. So P.O. Sullivan, I'm going to swear you under oath, as well as Mr. Reynolds, I'm going to swear you under oath as well. So can you please raise your right hand?
Yep.
You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give during this case should be the truth, the whole truth, and nothing but the truth to help you God without penalty of perjury?
I do.
I do.
So P.O. Sullivan, would you like to say anything at this time regarding the charges?
I mean, other than this situation, he has not had any misconducts, no additional issues. So, I mean, this just, I mean, obviously, this is a domestic issue that hopefully they can, move on from. But it just can't continue to happen.
Thank you. All right, is that offense opportunity? If I could speak to any evidence submitted?
Yes, just regarding that charge. Good morning, P.O. Sullivan.
Morning.
It appears, I know that his parole supervision status changed. In your narrative, you indicated he was released on parole on October 7th of 2020. He has not had any misconducts or violation while on supervision. Is that correct?
That he has had no, I'm sorry, it went out. What did you say?
Misconduct or violation?
No, he has not. He has not had any, no.
Okay, and the incident that occurred on December 11th of 2024, I'm not disputing something occurred on that date. In your parole violation report, indicated you were involved in a domestic altercation with your wife, and then in parentheses, you have victim. The wife was the victim in this case, correct?
Right. Yes.
Right. Are you aware that the incident that occurred on December 11th of 2024, it was a dual arrest, meaning?
Yes.
Okay, you're aware that the wife was also arrested, correct?
Right.
Okay, and so Mr. Reynolds was the victim in her case, correct?
Right. And I did write that in the narrative.
Okay,
That they were
and
both
I just
placed
want to
under
make sure
arrest.
you were aware it was a dual arrest.
Yes.
I knew the answer to your question, but I have to ask it on the record. You're aware they were both
Yeah.
arrested? Okay, all right. So Mr. Reynolds, the incident that occurred on December 11, 2024 with your wife, is it fair to say, based on the exhibit E, the Waterbury Police Department, you made the call, the 911 call to the police department, correct?
Yes, I did.
And you remained on site when the police showed up and you gave them your version of events, correct?
Yes, I did. The 911 operator stayed on the phone with me, so she could prove that I never put my hands on my wife at all.
Okay, and then you went to court. Your wife also went to court, and you disposed of your case. Looks like on March 7th of 2025, correct?
Yes, sir.
And it was in what's called an Alford doctrine plea. You didn't agree with everything in the police report, but you accepted that disposition because of your parole status, and you were incarcerated because of the parole status, correct?
Yes, sir.
Okay. Are you aware, Mr. Reynolds, of the disposition of your wife's case? What happened with her case?
Not really, only what you told me
Okay.
that.
Well, I'm gonna put on record. I just want to put on a record. It was a dual arrest on December 11th of 2024. Anticipate you're gonna make a finding of the preponderance of the evidence. There was a disposition in court. So I want to add a couple of things to the record. First of all, my client did plead under the Alford doctrine. He did have an attorney in court. They did do an investigation regarding the facts of the matter. And I do have confirmation that his daughter, who was at the other end of the line when the dispute occurred, does confirm that she was on the phone with Mr. Reynolds at the time. The problem is with the status that Mr. Reynolds has, because he's on parole, he's treated differently, has special status, which I understand. And this was going to be a trial, but unfortunately, he's going to remain incarcerated because of the parole remand until the case is resolved. So he did with the advice of counsel, accept the 4 months under breach of peace under the Alford doctrine. And just to make a point regarding the different statuses, his wife's case was resolved with creating a public disturbance, which is an infraction. They were both charged with the same conduct, but because she has a different status than Mr. Reynolds, she ended up pleading to an infraction. I just want to make sure that is part of the record. Thank you.
Thank you. All right, so what I'm gonna do next is I'm going to announce my findings. So on that charge 1, I do find you violated that condition, obedience to the law based on your conviction of breach of peace second and received a sentence of 4 months jail. That concludes the fact finding portion of the hearing. Before I make recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. So P.O. Sullivan, would you like to say anything at this time? We might have lost her. We're gonna give it 1 second to see if she can come back on. Chris, do you see? Oh, she's there.
Sorry, I just got kicked out.
That's okay.
I'm sorry. Okay.
Would you like to say anything?
I mean, obviously the domestic situation isn't working out, so I'm hoping that he can find somewhere else to reside. Other than this incident, I have not had any issues with Mr. Reynolds. So moving forward, I hope that, this doesn't persist. But either way, I know that you did call the cops, which was, the right thing to do, but it definitely must have escalated prior to doing that. I do hope that when you get out, you do continue to, go to school, work, and, take care of your health. But other than that, no, I don't have anything else to say.
Turn over counsel.
Yes, on behalf of Mr. Reynolds, I am respectfully requesting he be reinstated as soon as possible. I understand this is a domestic incident, and there's issues in the past, but this is a pretty good stretch of time, in my opinion, how long he was on supervision. And to P.O. Sullivan, I'm glad she's actually here today, because it does indicate there was no issues until this occurred. And once again, I know it's a domestic. He did. I'm not sure what else he was supposed to do, but call the police to try to get some intervention. And they're both arrested, but at the end of the day, my client is treated much differently than the victim, the other half of the victim in the case, which I don't think is fair. But court does things one way, we do things here another way. My client is 59 years old. He does have 7 children. He's got numerous support from family members in the area, including his mother, his 4 brothers, his sisters, and stepsisters. Upon his previous release, he did successfully complete the Connection, the REACH program in Torrington. He also was with the victim at one point, and then he was remanded. As far as his education, he's currently enrolled in the criminal justice program at Post University. I did submit Exhibit 2, which is a spotlight on Mr. Reynolds on how well he's doing in the program there. He's also been a member of Online Honors Program, a senator in the Online Student Government Association. Currently a sophomore, holding a 3.98 GPA. He's made the Dean's List, Honors List on a regular basis. While he was residing in Waterbury, he was working full-time in Compassion and Care in Prospect. Reportedly attended and spoke at local 12-step meetings, sharing his story. Fortunately, was diagnosed with congestive heart failure in Brooklyn in CI in 2019. He did receive, it looks like, a full heart transplant at Yale New Haven Hospital in October of 2021. He was involved in community service as indicated, helped collect clothes, socks, coats for St. Vincent's de Paul thrift store in Waterbury. They also sent groceries to St. Vincent's de Paul's shelter. And he was involved in that, using his own money to purchase some of the items. As indicated already under other information, we did put, since his release, he has not had any conducts or violations while on supervision. He does attend Bible study and church services in the facility on Mondays and Thursdays. He does have a sponsor. He did list his daughter, lives in Plainville, provided you her address and the phone number. So he is going to be going away, getting away from there. It's also my understanding that he's in the process of filing for divorce. Is that correct, Mr. Reynolds? To get away from that situation? Okay. He does want to return to the criminal justice program at Post in Waterbury. And he's indicated to us he's able to return to his full-time job at the Compassion and Care in Prospect. And apparently he has a company vehicle that they give him, and he's amenable to any treatment recommendations, which I don't think, based on P.O. Sullivan's comments, there hasn't been no way. So whatever they've asked him to do, he's been doing. Obviously, this arrest on 12/11/2024 was not on the agenda, but he has been doing what he's supposed to be doing while in the community. Thank you.
Thank you. Anything else from either side?
I don't have anything else to add.
No.
Okay. So I've listened to testimony and I have reviewed all the evidence provided by the state, and we'll put on the record. The offender has been on special parole for about 2 years and 7 months with no misconducts or previous violations received. As noted, same thing on discretionary parole that you were on. You did not receive any misconducts or any parole violations. You are on special parole for 10 years till 2032. There is a history of domestic violence, and you did receive a new conviction for breach of peace second, received a 4-month jail sentence. That sentence is completed on April 13th. That will be done. Based on the information and testimony provided today, I am going to, based on all that information, recommend that parole be revoked and that you be re-paroled for April 17th of 2025. It's about a 4-month period of confinement as a sanction, and you will have completed that new sentence you received. I also recommend the following parole conditions: no contact with your victim NL and CR without PO's permission, and behavior management program for domestic violence. My findings go to the parole board on April 17th. So if the board agrees with me, you'll be released that day. That's the soonest date that I have. They can also impose a longer sanction if they would like to, just so you're aware of that. If you did stay past 4/17, the board then would send you a notice letting you know why, and then you talk to the board. You come before them for an additional supplemental hearing, and they would talk to you if they do want a longer sanction. Do you have any questions?
No.
Okay, so
I
plan to
just
send
want
you.
I just want to state that all the stuff that I did, I'm not gonna lie, my soon-to-be ex-wife was a part of it. She did help me out, and it was just a poor error of judgment. And I regret what happened. I'm deeply sorry about what happened. It's just not working out between us, and we both understand that. And I'm gonna go my way. I'm not gonna bother her. I got a lot of good things going on. I'm a deacon in my community, and I just want to do the right thing.
All right, well, I'm glad to hear it, and I hope you keep up with the good work that you have been doing. And we wish you the best of luck, sir.
All right, good luck, Victor. Victor, if you don't get released on April 17th, that means they didn't accept the recommendation. I'll reach out to you. Hopefully that doesn't happen. Based on what I see here, hopefully you're out on April 17th, okay?
Okay.
All right, good luck to you. Thank you, P.O. Sullivan.
Thank you. Thank you, P.O. Sullivan.
Yep.
Bye, Ms. Sullivan.
Bye.
Have a good day.
You too, man. See you later, sir. Do I need to call you?
You don't need to call anybody.
Okay.
Good morning.
Hi.
Hi, is Mr. Nolan?
Yes, I'm gonna grab them for you.
Great, thank you.
Appeal.
Back there, and you're gonna see there's a video going on there right now for it. Just have a seat right there in the chair. All right. They see you. Okay, I'm gonna close this door for you.
Good morning, Mr. Nolan.
What are you doing?
Good. We're here for your revocation hearing today, okay? I have your attorney here. So
Yes,
we're gonna get started, okay?
Yes, ma'am.
Good morning. I am P.O. Meisinger, a hearing examiner for the Board of Paroles and Paroles. This is a revocation hearing concerning Nolan Lawrence, number 103577. Today is April 8th, 2025. This hearing is being conducted via video at the BOPP Central Office in Hartford Correctional Center. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
It's Lawrence Nolan, 103577.
Thank you. And you have counsel here?
Attorney
Yes, I do.
Alfonzo Sirica, public defender with the Parole Revocation Unit on behalf of Mr. Nolan this morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weight your evidence must establish that more probable than not the allegation is true. If I do not find that there is a, you can sit down, sir. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which means releasing and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. All right, so this is the procedure for today, sir. So I'm going to read you your rights. Then we're going to review the parole violation charge that the state, your parole officer, is bringing against you. I'm going to review and identify exhibits filed for the record. Counsel is then going to have an opportunity to present a relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure right now?
Yeah, I ain't violating nothing. I did what they told me to do. They told me
Mr.
to
Nolan,
do
she's
it.
just asking you, do you have any questions about the procedure? You understand the procedure, correct?
Yes, I'm with you.
Okay.
So your important rights, you have the right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
If I may, my client did receive the notices. Unfortunately, based on his level of education, he can't read and write very well, but I did explain to him what the charges against him are and what evidence I have.
Okay. So you have a right to view the evidence. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses or cross-examine diverse witnesses. Did you understand these rights and are you ready to move forward, sir?
Yes, I did.
Okay. So you'll now review the charge that the state your parole officer is bringing against you and the information underlying each charge. So that charge 1 is absconder. In your charge, your officer reported on July 30th, 1982, you were sentenced to 10 years to life for felony murder. On September 9th, 1985, and again on October 28th, 1993, you signed Connecticut parole conditions acknowledging that you were responsible for reporting to your parole officer, notifying your parole officer of any changes in residence, and notifying your parole officer of any arrests. In March of 2000, Florida submitted a violation report wherein they reported your arrest for DUI, which occurred on May 30th, 1999 in Winter Springs, Florida. They further reported that you failed to report the arrest within 48 hours and that you left your approved residence without the knowledge or consent of your parole officer. On December 11th, 2000, Connecticut Parole issued a memo that you had bonded out on a DUI and had not reported to your parole officer since that arrest. Since that date of 12/11/2000, you have not made any attempt to contact your parole officer to address these charges, nor have you made an attempt to report to your parole officer. As such, it is reasonable to believe that you have intentionally evaded parole supervision. And the state has filed the following exhibit that is pre-marked for identification purposes. Exhibit A is minimus, B, Connecticut parole condition, C, misconduct report, 1993, D, memo, RE supervision history, E, ICAOS application and related transfer information for 1998, F, Florida parole violation report 3/2000, G, Connecticut parole violation report 4/2000, H, CT parole warrant 4/2000, I, Connecticut parole supervisor's memo failure to report, J, Florida's note, RE subject still at large, K, case notes, unable to serve warrant due to absconder status, L, address associated note with Nolan, M, parole violation report, N, notice of parole violation, O, remand to actual custody order, and P is waiver of extradition. Did you receive the notice of parole violation report, and the other documents I marked, and did you review them with your attorney?
He did. We did
Okay.
go over documents, yes.
Okay, and council has filed the following exhibit that's pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
We have no witnesses today. I will put on the record, the addendum did report on 4/20/2000. The BOPP did issue an absconder warrant for the offender. So it's now a defense opportunity. Would you like to speak to any of the evidence at this time?
Yes, regarding this charge thing goes back sometime. Mr. Nolan,
You want him sworn in?
yes,
Mr. Nolan, I'm going to swear you in under oath today so you can speak. So can you just raise your right hand for me? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
I do.
Okay, so we can put your arm down.
so Mr. Nolan, the allegation here is that you absconded from parole some time ago, 20+ years ago, but it was your understanding that you had completed your period of supervision, correct?
That's correct. That's correct.
Okay, and somewhere along the way, I believe in $1999, you were charged with DUI in another state, correct?
That's correct.
Okay, and you went to court, you took care of that case, correct?
That's correct.
Okay, at that time, allegedly, you were on parole supervision at that time, correct?
That's correct.
And you were able to post bond on that driving under the influence charge, correct?
That's correct.
Okay. At any point in time, were you advised that you had a warrant in the state of Connecticut for absconding from parole?
No, I didn't have that.
Okay. And they allowed you to post bond and you were released on that charge, correct?
That's correct.
Okay. Where have you been living the past 20+ years?
Williamstown, New Jersey, with my aunt.
Okay. And you've
Williamstown.
been at that same address how many years?
Over 30 years.
Over 30 years. You've been in the same address in New Jersey, correct?
Correct. That's correct.
Okay. And where were you picked up on this absconder warrant? Were you picked up in New Jersey?
Yes, I was at my aunt's house.
Okay. And you've been at your aunt's house for 30+ years, correct?
Yeah, that's correct.
Okay.
Yes.
I don't have anything else to add. I do have, I believe it's Exhibit D. There is a memo from the Department of Correction Walker Reception Center, which I don't think that's even open anymore. It's an interstate compact office, which kind of gives the breakdown as to Mr. Nolan's history, what occurred, why he was able to bond out and allowed to bond out and allowed to go to court for his case and not picked up and brought. They knew where my client was. They knew he picked up a DUI, and there was another incident that occurred where I believe it was $125 fine. As I indicated, my client is very, very low education level. I believe 7th, 8th grade. His understanding was that believed he had completed his period of supervision based on the fact that he wasn't extradited when the DUI occurred in Pennsylvania. So he thought he was done with his supervision. And also along the way, there's a claim that my client did pay for private attorney for a sentence modification. I don't have any documentation regarding that, but after speaking to Mr. Nolan, his understanding was that if there was a extradition warrant to Connecticut, that DUI would have triggered an interstate action to have him brought back to Connecticut. And on the flip side, he was able to postpone. He did go to court. He did take care of that DUI. Why he wasn't picked up, if the paperwork was lost in between the two states. This goes back, that memo goes back to 1993. I've been a lawyer for 20 plus years. I believe I undergrad studies back then. So this goes back some time. So I just want to put that on the record. And as I indicated, my client has been at the same address in New Jersey where they finally picked him up for 30 plus years with his aunt. Thank you.
Thank you. All right, so what I'm gonna do next is I'm going to announce my findings. So on that charge 1, I do find you violated the condition release direction absconder based on a warrant being issued by the BOPP and evidence provided in support of the charge, which is exhibits B, E, H, I, J, K, M, and P. That includes the fact-finding portion of the hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to.
Yes, on behalf of Mr. Nolan, I am respectfully requesting to have him reinstated as soon as possible. To say this is an unusual case is an understatement, given the time frame here. My client, he's 73 years old. He does have 4 children. As I previously indicated, he's been at the same address in New Jersey, taking care of a 93-year-old aunt. And that's where he wishes to go back to as far as reinstatement. He was previously sponsored by his mother and father in Philadelphia. Then he got married. He actually even purchased a home with his wife back then at the time. And then he separated from his wife and he's been living with his aunt, as he indicated, for 30 plus years. While he did have work history, did do some painting of houses. He also worked for Associated Cleaning Consultants in Pennsylvania, and also for a waste disposal company in New Jersey 4 months. He does currently receive disability for medical purposes. Does have significant medical history for high blood pressure, seizures. He's had two strokes recently. He is currently medication compliant, and all his medical providers have been established in New Jersey. And it appears in 1992, New Jersey did report they recommended Mr. Nolan to be considered for early discharge. Based on that memo, it looks like he was doing everything he was supposed to be doing. I did indicate the address and the phone number of the individual he'd like to go back to. That's where he was remanded from, and he's amenable to any recommendations that's required for him. His main thing is medical issues, like as I indicated, has suffered from seizures and recently 2 strokes, so he does need medical attention. Mr. Nolan, anything you want to add about your background that I left out that you want the hearing examiner to know?
Oh, Dad, I gotta take this. I was on parole and my parole was retired to get a good job, take out trouble and go home. And that's what I did.
Thank you.
All right, so I'll be right with you with my recommendation, okay?
Yes, ma'am. And thank you, sir. Thank you.
Okay, so this is, I listened to testimony, I reviewed all the evidence. This is the offender's first violation of parole. He did begin parole back in October of 1985. So he had been out for about 14 years and 6 months prior to receiving the absconder warrant that was issued in 2000. There's one noted misconduct from 1993. Based on the information that I have, I'm going to recommend that parole be revoked and that you be reparoled for April 28th of 2025. This is about a 3-month period of confinement as a sanction. This includes for when you were brought into custody in New Jersey on January 28th of 2025. So that ends up being about 3 months from that return to custody. I also recommend the following parole conditions. Parole to another state of New Jersey. No contact with victim family of RL. No contact with your co-defendants, Christopher Lecken and Teresa Spencer. And I'm putting halfway house placement on there, just in the event that there's a issue going back to Jersey, but I don't anticipate that. April 17th is when I present this to the parole board. So I'm going to present your case to the parole board on April 17th. So if the board agrees with me, you'd be reparoled on April 28th. Okay, sir? So the board can also decide to hold you in longer if the parole board wants to, okay? So if they want to hold you in longer, you would get something in writing, and you can also speak to your attorney, okay? Do you want to say?
Yeah, what? Is he considered special parole?
He's on discretionary parole.
I don't have to.
Yeah.
All right, so Mr. Nolan, she's asking for you to be reparoled on April 28th of 2025, okay? But given the type of parole you're on, the discretionary parole, it's on or after, so they don't have to necessarily release you on April 28th. There might be a couple of weeks after that if the board adopts the recommendation, okay? So I think what I'm gonna do is you're on for the board review. I'll set up a call with you the following week prior to the April 28th to let you know what the parole board did to make sure you're getting out shortly thereafter. So I will set up a legal call with you, okay?
All right, thank you, thank you.
Mr. Nolan, just know that you are on special parole. There's no end date, okay?
Yes, ma'am.
So you gotta make sure that you communicate with your officer, okay?
I will.
I'll cover that.
I will have no problem out of me.
Okay,
All right,
so you're all set for today, sir, okay?
I'll give you a
Yes,
call.
ma'am. All right, thank you, sir.
All right, good
All right,
luck.
thank you. Thank you. God bless y'all.
Have a good day.
Yeah, both have a good day. Thank you. Okay. All right.
What's
Hey,
up,
Alfonzo.
Rob?
Hey,
I came back and office is empty. You booked on me, man? What's up with that?
I'll be
We'll
back.
chat soon. We'll chat soon. Are you,
All right.
have you started over there yet?
Yeah, I'm there now.
Oh, good. Good for you.
Thank
Good for
you.
you. Take care.
You too. Morning, Caitlin.
Good morning.
Good morning.
Hi, can I have Cologne first and then Lee?
Okay,
Thank you.
you're welcome. Cologne.
Morning, Mr. Cologne.
Morning.
Morning. And Attorney Famigliett, you can hear me?
Say it again.
Yes, good morning. Good
No, I'm
morning.
talking to your attorney. Good morning.
Good morning, sir.
All right, so we're gonna get started with your revocation hearing, okay?
Okay.
Good morning, I am P.O. Meissner, hearing examiner for the Board of Paroles and Paroles. This is a revocation hearing concerning Cologne Hector number 427733. Today is April 8th, 2025. This hearing is being conducted via video at the BOPP Central Office in Osborn Correctional Institution. It's a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Hector Cologne, 427733.
And you have counsel here today. Please identify yourself for the record.
Yes, good morning. Public Defender Robert Famigliett of the Parole Revocation Unit. Hello, sir.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better read your evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is release you and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge the state your parole officer is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay. You have important rights. You have the right to have an attorney present. You have counsel here. You have the right to receive the written notice to charge the violation. Did you receive the written notice?
Yes, I have it right here.
Okay. You have a right to view the evidence. You have a right to submit evidence supporting your case at this hearing, right to call and examine voluntary witnesses and cross-examine diverse witnesses. Do you understand these rights, and are you ready to move forward?
Yes.
All right. So we'll now review the charges that the state your parole officer is bringing against you and the information underlying each charge. So charge 1, release restriction GPS. You're charging officer reported on 7/3/24. You signed a GPS monitoring agreement, agreeing to abide by the rules of the GPS electronic monitoring system. On 7/6/24, you allowed your GPS unit to shut down from 12:43 a.m. to 12:50 p.m. On 7/7/24. Your whereabouts during this time were entirely unknown. On 7/9/24, you allowed your GPS unit to shut down from 8:07 a.m. to 2:08 p.m. Your whereabouts during this time were entirely unknown. On 7/15/24, you allowed your GPS unit to shut down from 10:14 p.m. until 1:37 a.m. On 7/16/24, your whereabouts during this time were entirely unknown. On charge 2 under Ohio laws, obedience to the law, you're charging officer reported on 10/24/24. Members of the Greater Hartford Regional Auto Theft Task Force and Hartford Police Violent Crimes Unit were provided information that a green 2009 Honda Accord bearing registration had been stolen in Wethersfield and observed by Wethersfield Police Department to be traveling into Hartford. It was reported the vehicle was driven by a single occupant wearing dark clothing. You were later identified as being the sole occupant of this vehicle. You were observed by members of the Hartford Police Department to be traveling through various streets in Hartford, eventually parking at McDonald's on Washington Street. At the time you parked the vehicle, members of the Hartford Police Department converged on the vehicle, activating red, blue lights, clearly indicating that they were members of law enforcement. You immediately exited the vehicle and ran away from responding officers. You disobeyed several lawful commands by Hartford Police Department to stop and proceed to engage police in a foot chase through several streets, fences, and back lots until you were apprehended by Hartford Police Department. Based on your actions, you were arrested and charged with larceny of motor vehicle, use of motor vehicle vessel without permission, larceny 3rd degree, interfere with no officer, resisting arrest. And 10/25/24, you were arraigned in GA 14 Hartford. Probable cause was met and bond was set at $50,000. Charge 3 under halfway house placement. Your charging officer reported on 4/11/24. You're given a community pass to the reentry center. Chase Center staff conducted a spot check at the center and informed that you attended but left and provided an excuse that you forgot your bus pass, had to leave. Reentry center is 20-minute walk from the Chase Center. Your whereabouts community were entirely known for approximately 1 hour and 15 minutes. This is in violation of the written rules of the halfway house on 5/7/24. You were given a community pass to attend treatment at Wilmore from 4:54 p.m. to 7:20 p.m. A review of your cell phone discovered a photo of you timestamped on 5/7/24 at 5:27 p.m. smoking in a car. This is a violation of the written rules of the halfway house as well as halfway house agreement. You were never provided permission to drive or be a passenger in the vehicle. On 5/19/24, you're given a community pass to attend church from 9 a.m. to 11 a.m. A review of your cell phone discovered a photo you timestamped on 5/19/24 during those times in a car with a stack of money. This is a violation of the written rules of the halfway house as well as halfway house agreement. You were never provided with permission to be in or be a passenger in a vehicle. On 6/6/24, you're given a community pass from 1:11 to 2:51 p.m. A review of your cell phone discovered a photo of you timestamped 6/6/24 at 2:08 p.m. smoking in a car. This is a violation of the rules of the halfway house as well as the halfway house agreement. You were never provided with permission to drive or be in a passenger in a vehicle. On 6/25/24, you're found by Chase Center staff to be in a room of another resident in an unauthorized area. This is in violation of written rules of halfway house. On 7/2/24, staff at Chase Center confirmed with Wilmore that you had completed treatment. On 6/11/24, on 6/18/24, you're given a treatment pass from Wilmore from 4:30 p.m. to 6:33 p.m. You do not attend treatment. Your whereabouts during this time were completely unknown. This is a violation of the written rules of the halfway house. On 6/25/24, you're given a treatment pass to Wilmore from 4:30 p.m. to 6:26 p.m. Yet did not attend treatment. Your whereabouts at this time were entirely unknown. This is a violation of the written rules of the halfway house. On 7/9/24, you're observed by halfway house staff attempting to open the door to a room that you were not assigned to. They directed you over the house loudspeaker to not open or enter the room. You deliberately ignored staff orders and proceeded to open the door to the room despite being told not to. This is a violation of the written rules of the halfway house. On 7/10/24, a search of your cell phone was conducted. It was discovered that you had taken multiple pictures of female staff from behind without their knowledge. This is a violation of the written rules of the halfway house handbook, not allowed to take pictures inside the program. Charge 4 under no driving. Your charging officer reported on 10/24/24. You're observed by Hartford PD as the sole operator and occupant of a green 2009 Honda Accord. You do not have permission to operate a motor vehicle. And the state has filed the following exhibits pre-marked for identification purposes as Exhibit A, signed conditions of parole, B, remand to custody form, C, notice of parole violation, D, parole violation report, E, signed offender misconduct, F, signed GPS monitor agreement, G, L, universal report, H, Hartford Police Department incident report, I, signed halfway house agreement, J, community solutions incident disciplinary action reports, K, residential disciplinary reports, L, Chase Center incident reports, M, Board of Pardons and Parole decision information summary, and N is Chase Center handbook. Did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yes, we have.
Okay, and council has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
Okay, so I do want to put on the record that I did receive an addendum from PCS. The addendum reported on 3/19/2025, the offender was convicted of larceny of motor vehicle first offense, received a 2-year jail sentence with all other charges nollied. I have an EUS date of 3/17/27. That's an overall release date as the offender is on discretionary parole with the pending eligibility date of 3/18/26. We have no witnesses today, so now it's defense's opportunity. If you'd like to speak to any of the evidence submitted at this time.
Yes, I have an initial question. The PVR itself lists his date of release to parole as 8/12/24. Is that correct?
Yes.
He was released on 3/12/24.
Okay, because it says 8/12/24. So some of the sir, now is not the time for you to.
I'm sorry.
Okay. So he was released to the community and he's been supervised since 3/12 because all the documentation says 8/12.
It could be when that he was released to that officer or that district. 3/12/24 is when he was released to supervised parole.
Okay, thank you.
Yep.
It was just confusing because a lot of the conduct happened before 8/12. So regarding the GPS, I have no comment as to the preponderance standard. Regarding obey the law, I have no comment as to the preponderance standard. And regarding charge number 4, I have no comment as to the preponderance standard. However, as to halfway house placement, we have no idea when these photos in the car were taken. We don't actually have copies of the photos. As to, and I broke this down into a number of parts. Some of the allegations under halfway house placement list the condition. I will not operate a motor vehicle, or another condition it lists. I will only go to the locations necessary. I would ask that a no finding be made for any of the subsections that end with this is a violation of the written rules of the halfway house. It doesn't list a specific rule. There's no way for me to defend. There's no way for me to research what the elements, what the conditions, the exact condition was, what the language of the exact condition was for him to violate. So that would be the first part. That would be the paragraphs. The first paragraph. One moment. The fifth.
You could say the dates.
What's that?
You could say the dates. Yeah, the dates that you're talking about.
4/11/24. I would 5/7/24. I'd argue that there's no foundation. There's no way of telling when that photo was took and who placed that on there. And there's no foundation laid. The same for 5/19 regarding the photo. The same for 6/6 regarding the photo. 6/25. There's no indication as to what specific rule. 7/2. There's no specific rule noted. Then jumping to 7/9, there's no specific rule noted, and I don't think it's a violation to open a door. And then the last one is the photos. There's no specific rule cited. Thank you.
Thank you. So I'll be right with you with my findings.
Thank you.
All right, so I'm going to announce my findings. So on that charge 1, I do find that you violate that condition GPS based on evidence provided, which is exhibits A, E, F, and G. On charge 2, I find you violate condition abuse of law based on your conviction of larceny, first motor vehicle, first offense, and received a sentence of 2 years jail with all the charges nollied. On charge number 3, I find that you violated condition halfway house placement based on evidence provided A, E, I, J, K, L, N. I make a no finding on the 7/9 date, insufficient evidence on that date. On charge 4, I do find you violate condition no driving based on evidence provided, exhibits A and H. So that includes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, my client was on supervision for about 7 or 8 months before he was remanded. It's noteworthy that his sentence began on 3/19/25, and for some reason he wasn't given credit from 10/25/24 until 3/19/25. So he apparently lost 5 months credit towards his sentence for some reason, even though he was held. So I'd ask you to take that into consideration when fashioning a sanction. For charge 1 GPS, he had only been on the GPS in July from July. So those are the first few days, 7/6, 7/9, and 7/15 that he was on GPS. From that time until October, he was without any violations. I don't believe any of the halfway house placement violations are serious. And as to the no driving, this is a case where he was in possession of a stolen car. There was no indicia that it was stolen. There's no damage to the car. There's no statements in the report that he did or didn't have the keys. He may have been loaned that car from someone else. This is his first violation of parole. His misconducts go to the conduct that's in the parole violation report. This is a discretionary parole. He is a single 23-year-old male. His significant other is Jesselyn Alvarado. He receives support from her, from his mother, his brother, and his sister, who is also his significant other's best friend. He had been calling barber schools to gather more information in an effort to start. He wishes to start in a cosmetology program. He attained his high school diploma at MYI, and in the past, he's worked in the roofing industry. He obtained anger management at Wellmar in the past, behavioral health. He also went to CPA, alternative and AIC to complete the R&R program. He also was receiving biweekly individual psychotherapy in the past at Wheeler Clinic, biweekly. He was placed, as I said, on July 3rd on GPS monitoring and only had those initial violations. He wishes to be placed with his significant other, Jesselyn Alvarado. Prior to remand, his brother paid for him to complete a flagging course because his brother works at American Flagging LLC out of Waterbury, and he believes he can be employed there. He's going to be serving this sentence for quite some time. It's a 2-year sentence. He did lose the 5 months. This is a non-violent crime. We're asking that he receive a 6 to 9 month sanction. I know his parole officer is requesting an additional 12 months. I think that's draconian for an initial non-violent violation of parole. We're asking for a 6 to 9 month sanction beginning in October of 2024. I think that's appropriate. I think that is a deterrent, and I don't think any further time is necessary. This will allow him to perhaps TS or parole at 50% on the 2-year crime that he took. Thank you very much.
Thank you. I do want to note his eligibility date that he can parole is 3/17/26. So that's
without the 5 months of credit. We're hoping he can gain that 5 months of credit through a modification with his original attorney. That's why I'm asking for that here today. Thank you.
Okay, but I wouldn't be able to do any sooner than March 17th to 26th. That would be the soonest that I'd be able to, because that is the eligibility date that I have at this time.
Okay, but then would we be able to ask the parole board to change that if his sentence is changed? There's no avenue for us to do that. That's why we're asking for a
No, but I can't give anything before that because he's not eligible until March 17th to 26th.
We would ask for that date then.
Okay.
Thank you.
So I'll be right with you with a recommendation. All right, so I have reviewed all the evidence and I've listened to testimony today. I will put on the record, the offender was in the community on discretionary parole for approximately 7 months before receiving this new arrest and receiving a new 2-year jail sentence for larceny motor vehicle first offense with other charges not lead. I do want to put on the record, the offender has displayed the same pattern of behavior that he is currently on special parole for, which includes larceny, evading responsibility, interfering with an officer. So that to me is concerning that the same behavior is being displayed over again, even though you're on discretionary parole and you're giving this opportunity by the parole board and you're still doing the same behavior. So that is concerning. And you're only out there 7 months. Based on this information, I am going to recommend that parole be revoked and that you be re-paroled for October 23rd of 2026. This is an approximate 2-year period of confinement as a sanction. I recommend the following parole conditions: halfway house placement. Actually, you have a sponsor, so I'm putting your sponsor information. So just operation of motor vehicle and no contact with your co-defendant, Kevin Bermudez. My findings are going to the parole board April 17th. So the board can agree with me. The soonest they can let you out right now is March 17th of 26. I'm recommending you do the 2 years, which is the October of 23rd of 26, which is the 2 years that you received for that new sentence, allowing you remaining months in the community to be on parole supervision in the community before you discharge the special parole, which you have 8 years special parole to follow. So I'm trying to give you a discretionary period one more time before you are off, because this is your first violation. You did have problems in the halfway house. I'm hoping if you go to a sponsor's house, you're going to be compliant and follow the directions of your parole officer. But the board can agree with me. As I said, they can let you out that date that you're the earliest date, that PED date, or they can max you out and have you discharge a special parole. So it's going to be up to the parole board. So you're going to know after April 17th. So they're going to send you something in writing. So you're going to know what their decision is about a week after you get it in writing, or you could talk to the attorney's office here after the date of 4/17. I don't know if Attorney Pimgott, if you want to say anything.
Yes, briefly, sir. So 4/18 is a holiday. Okay. So after 4/17, call us the following Monday at our office and we'll tell you what the board decided. Okay, sir?
Okay.
Okay. Any questions? Regarding that credit,
yeah,
you're still going to have to do whatever they give you as a sanction, even if it's longer than, you know what I'm saying? If parole gave you the 2 years and if the board agrees, you won't be able to parole sooner than that. Do you understand that? If they do lessen the sanction, and we'll tell you that on the following Monday, you should contact your attorney in Hartford to try to get that credit back. Okay?
if they give me less time?
If they give you less time, you should call your attorney. Yes.
Okay,
Okay.
so
I think it's Attorney Arnett.
yeah,
You won't know until the Monday after April 17th, which is April 21st. So on April 21st, call the office. Okay?
yes.
Okay, so good luck.
You're all set for today.
All right, thank you.
Good luck, sir. Thank you, Attorney Pimgott.
Thank you, hearing examiner.
Best of luck to you too.
Thank you. It's great seeing you. I'll come back and say goodbye.
Okay, good.
Okay.
Have a good day.
You too.
Thank you, sir. How you doing, man? Hello, miss. Hello. Yes.
Morning, sir.
Morning, ma'am.
Mr. Lee.
Yes, ma'am.
So we're here today for your revocation hearing.
Yes, ma'am.
So I have your attorney here, so we're going to get started, okay?
Yes, ma'am.
Yes. Good morning. I am P.O. Meissner, a hearing examiner for the Board of Paroles and Paroles. This is a revocation hearing concerning Lee Raymond, number 262900. Today is April 8th, 2025. This hearing is being conducted via video at the BOPP Central Office in Osborn Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Name's Raymond Lee, inmate number 262-900.
You have counsel here today. Please identify yourself.
Yes, Hannah Dean for the record on behalf of Mr. Lee. Good morning, sir.
Good morning, ma'am.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of facts to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better we do evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is release you and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge, state your parole officer is bringing against you, and we'll review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
Oh, ma'am.
Okay. Your important rights. You have the right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am, I did.
You have a right to view the evidence against you, right to submit evidence for your case. It's here your right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
I do understand, ma'am.
All right, so now review the charge the state your parole officer is bringing against you and the information underlying each charge. Charge 1 under release restriction GPS, your charging officer reported 7/3/24. You signed a GPS monitoring agreement agreeing to abide by the rules of the GPS monitoring system. Specifically, it will remain in my approved residence between the following hours, 9 p.m. to 6 a.m. On 9/1/24, you turn home at 9:38 p.m. You do not have permission from your PO to be out past your 9 p.m. curfew. On 9/2/24, you turn home at 9:35 p.m. You do not have permission from your PO to be out past your 9 p.m. curfew. On 9/13/24, approximately 10 p.m., you were arrested by Enfield Police Department after being located intoxicated and laying face down in the yard of a private residence. You do not have permission from your PO to be out past your 9 p.m. curfew. Charge 2. Under a release restriction curfew, you're charging officer court at 9/1/24. You turn home past your 9. You return home at 9:38 p.m. You do not have permission from your PO to be out past 9 p.m. curfew. On 9/2/24, you turn home at 9:35 p.m. You do not have permission from your PO to be out past your 9 p.m. curfew. At 9/13/24, approximately 10 p.m., you were arrested by Enfield Police Department after being located intoxicated and laying face down in the yard of a private residence. You do not have permission from your PO to be out past your 9 p.m. curfew. Charge 3 under program participation. Your charging officer reported on 8/19/24. You do not attend your parole mandated domestic violence group. You do not have permission from your parole officer or program staff to miss the group, nor did you contact anyone from the program to inform them of any reason that would prevent you from attending the group. Charge 4 under obey all laws, obedience to the law. Your charging officer reported at 9/13/24, Enfield PD was dispatched to a motor vehicle accident. It was reported that the driver, later identified as you, of a Nissan Sentra, exited the car, fell on his face, and ran behind a nearby CVS. Enfield police went to Enfield Wine and Liquor, which was directly across the street from where the vehicle you were operating was disabled. Employees of Enfield Wine and Liquor were able to identify you and report that you were a common customer. Enfield Police Department reviewed town traffic cameras, which showed you operating a blue Nissan Sentra departing the Good Times package store minutes before the collision. Enfield police and their canine were able to track you and found you sleeping face down in the yard of private residence. According to the responding officer, you were so intoxicated that field sobriety tests could not be conducted at that time. You were detained and brought to Enfield Police Department, where you required assistance getting to the booking area because you were so unsteady on your feet. A dragger breath test was conducted, determining your BAC. You rendered a subject sample of 0.2299 and 0.2251. The owner of the blue Nissan Sentra you were operating was contacted by Enfield Police Department. It was reported the vehicle was brought to your garage for repairs and that you do not have permission to drive it. Based on your actions, you were arrested and charged with the following: use of motor vehicle without permission, interfering with an officer, driving under the influence, subsequent offense, third offense, evading a collision, failure to reinstate license after 60 days, and following too closely resulting in collision. Charge 5 under additional conditions, no consumption of alcohol and beverages. Your officer report on 7/1/24, you're found by East Windsor Police Department to be laying on the ground outside the residence under the influence of alcohol. You were sent to a hospital for evaluation. On 7/3/24, you registered a .13 BAC and a breathalyzer exam conducted by your parole officer. On 7/4/24, you're found by East Hartford Police Department unconscious on the ground under the influence of alcohol. You were sent to a hospital for evaluation. On 7/5/24, you're found by Enfield PD unconscious on the ground under the influence of alcohol. You were sent to a hospital for an evaluation. Charge 6 under behavior management program. Oh, excuse me, and this one more. 9/13/24, you're given a drug breath test by Enfield PD to determine your BAC. You registered a .2299 and a .2251 BAC. In charge 6 behavior management program, you're charging off support 8/19/24. You do not attend your full mandated DB group. You do not have permission from your PO or program staff to miss this group, nor did you contact anyone from the program to inform them of any reason that would prevent you from attending group. Charge 7, no driving. You're charging off for 9/13/24. You were involved in a motor vehicle accident as you were the operator of one of the motor vehicles. You have a suspended driver's license. You do not have permission from your PO to drive a motor vehicle. In the state is filed the following exhibits that are pre-marked for identification purposes. Exhibit A, signed conditions of parole. B, Raymond actual custody order. C, notice of parole violation. D, parole violation report. E, signed voluntary admission of positive test results for prohibited substances. F, email correspondence. G, signed GPS monitoring agreement. H, L, universal event history. I, L, universal map. J, signed misconducts. K, Enfield PD Department case insert report. L, state of Connecticut judicial branch pending case detail. M, board of pardons and paroles decision information summary. Did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yes, ma'am.
Okay. In council's file, following exhibit that's pre-marked for identification purposes, that's offense exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue to entertain any additional evidence?
We do not.
Okay, we have no witnesses. I will put on the record, I received an addendum from PCS. The addendum reported on 2/18/25, you were convicted of illegal operation of a motor vehicle under the influence. You received a 3 years jail, execution suspended after 18 months jail. This is the third offense for illegal operation of a motor vehicle. I have an EUS date on this sentence of 3/11/26 with a mandatory minimum of 9/12/25. And there is 3 years probation as well on that sentence with all other charges nollied. So it's not offense's opportunity. If you'd like to speak at this time.
Yes, thank you very much. As to the charges in 1 and 2, I would just note that the alleged violations on 9/1 and 9/2 are minimal. There were 38 minutes and 35 minutes respectively. And I did speak with my client regarding those incidents. My client reports as to the 9/1 incident, he was running late due to issues with his Uber. He doesn't have transportation of his own, so he was relying on ride shares at the time. And on 9/2, my understanding is there was an accident on the highway which resulted in his Uber being stuck in traffic and returning back to his home a little bit late. I will note in Exhibit I, you can see that my client's route from point A to point B did not deviate, and it was clear that he was in travel during that time period. He was on the highway clearly. Nevertheless, my client does report, however, on both occasions, I believe he did call his PO to update them regarding his whereabouts and the fact that he was running a little bit late back home. As to charges 3 and 6, I would argue that the preponderance standard has not been met. Nowhere in the evidence does it indicate that my client was discharged from Explore due to that one alleged absence. Even though this was marked as unexcused, my client reports he did call the program to update that he was running late due to transportation issues. And he reports that he did speak to someone who, based on that conversation, made him think that it was okay and it would be an excused absence. And only thereafter did he find out it was actually unexcused. Furthermore, Exhibit F does indicate, that he did complete 4 sessions. Nowhere does it say he was unsuccessfully discharged due to that one absence alone. And I would also point out that Exhibit F, the email from 8/21, indicates that he didn't attend the appointment the prior night, which would have been 8/20, not 8/19, as is being alleged. As to charge 4, obedience to the law, I would not make any comments regarding the preponderance standard, but I will just note that the addendum is correct. My client did go to court on 2/18, and that was correct. He took the plea for 18 months to serve 3 years probation. And then lastly, 5, for no consumption of alcoholic beverages. As to the incidents on 7/1, 7/4, and 7/5, I would argue that no urinalysis or breathalyzer tests were submitted for those to show that my client was actually under the influence of alcohol. So I would ask for a no finding on that that charge. And at the appropriate time, I would like to speak to his background and history.
What dates did you say?
The ones for consumption of alcoholic beverage was the 7-1, 7-4, and 7-5. Basically the ones where he didn't take the breathalyzer or urinalysis.
Yeah, so I'll be right with you with my findings. All right, so I'm gonna announce my findings. So on that charge 1, I do find you violated that condition GPS based on evidence provided, exhibits A, G, H, J, K. On charge 2, I do find you violated condition curfew based on evidence provided in support of the charge, which exhibits A, G, H, J, and K. On charge 3, release restriction program participation, I'm making no finding due to there being insufficient evidence to support that charge. There's no information that says you were unsuccessfully discharged from the program due to missing one group. On charge 4, I do find you violated condition obedience to the law based on your conviction of illegal operation of motor vehicle under the influence third offense and received a sentence of 3 years jail, execution suspended for 18 months jail with 3 years probation. With all our charges nollied. It's all based on, evidence also exhibits A, D, and K. On charge 5, I do find you violated condition no consumption of alcoholic beverages, not on the dates 7-1, 7-4, 7-5. So no findings on those 3 dates as there's insufficient evidence to support the charge on those dates. There is finding on the dates of 7-3 and 9-13. And on charge 6, behavior management program, I'm making no finding due to there being insufficient evidence to support the charge. There's no information that says the defendant was unsuccessfully discharged from the program due to missing one group. On charge 7, I do find you violated that condition no driving based on evidence provided, which is exhibits A and K. So that includes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, and Mr. Lee, I will get to you once I'm finished speaking so that you could read that as well.
If you do want to speak today, I'm just going to swear you in under oath right now then so that you can speak. Can you please raise your right hand for me? You solemnly swear, sincerely affirm as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth to help you God without penalty of perjury?
Yes, I do, ma'am.
Okay. But
yes, thank you very much. I'll turn it over to you in just a moment, Mr. Lee. So my client, Mr. Lee, is 43 years old, born in Hartford, Connecticut, raised between Massachusetts and Connecticut. He has one son who just turned 18, who resides with his mother currently. Upon release from Sapolsky in November 2023, my client successfully completed Renaissance East in Waterbury. He then was self-sponsored and addressed in Waterbury for approximately 2 months until he transitioned to a new residence in Hartford, where he was residing up until his remand. In 2024, my client reports that he became a certified recovery coach through CCAR. In 2013, he initially established his own business, Ray's Automotive, located in Enfield. Since being released on special parole, he changed his business name to Lee Enterprises. He reports participating in the Explore DB program through CHR in Hartford and reports he completed approximately half of the program. Beginning July 12, 2024, my client reportedly voluntarily enrolled himself in IOP, individual therapy, and medication management at Wheeler Clinic in Hartford. He understood at that point that he wanted to do something to better himself as far as his drinking went, so he did take it upon himself to get himself into that programming. He does suffer from TBI due to a motorcycle accident in 2010. While on special parole, my client was on a maximum contact schedule with good regularity of contact. Since being remanded to custody, he's gotten no disciplinary tickets. He reports that he's been participating in Tier 4, which is due to successfully complete in May of this year. He reports that he has been also helping individuals build business plans while incarcerated, and he has been putting together a financial empowerment program to be offered to other inmates at the facility. He will be speaking on that more. I believe the letter he wishes to read is from some of the COs indicating the work he's been doing with helping them develop this program. But the financial empowerment will focus on commercial accounts, so how people can get a tax ID number, get exemption status, and also how they can become LLCs if they want to start their own business. He reports working with this recovery coach, Eric, through CCAR. Upon reinstatement on special parole supervision, my client's open to being placed in a halfway house in either New Haven or Hartford. However, he ultimately would like to be placed in a sober house so that he can focus on his sobriety. He also wants to return to his business. Ultimately, he would like to work as a recovery coach to help other individuals struggling maintain their own sobriety. He's eager to show his son a different way of living. He doesn't want his son to live the life that he did. He wants to show him that he can be productive and maintain sobriety well in the community. My client's biggest priority at this point is his sobriety. He's willing to undergo any treatment that's recommended to him, including successfully completing the Explore program and returning to Wheeler Clinic for outpatient services and utilizing CPAR for additional support. I am going to just note this was an unfortunate situation. My client suffered a relapse. He feels very strongly that if at that moment when he suffered the initial relapse, he was given inpatient treatment, he wouldn't be in front of you today. Unfortunately, that isn't what happened. And this, unfortunately led to him being reincarcerated. But I am asking that any extinction for my client not exceed 1 year to serve. He's been on parole since November 2023 with no issues. This was an unfortunate situation. He was struggling with relapse. However, since he has gotten remanded to custody, he's taken charge of his sobriety. He's been doing extremely well, helping other individuals. He has been incarcerated since 9/13/24. By virtue of the new plea, he'll also be starting 3 years of probation once he's finished, so he'll have additional supervision while he's in the community. So I am asking that any state should not exceed 1 year to serve. And at this point, I will allow Mr. Lee, if he would like to read the letter that I believe he got from the COs regarding that program he's helping them with.
Sure, go.
Yes, thank you. It says, Mr. Lee currently participates in the Tier 4 program. His anticipation on completing this program is 5/31/2025. He attends and participates in all group success sessions. Mr. Lee also always is present with a positive attitude. Mr. Lee appears to take responsibility for his actions. He provides group members with positive feedback and is receptive to any feedback that is offered to him. Mr. Lee has no issues complying with program rules and expectations. Mr. Lee has shared his financial literacy experience with members in the therapeutic community. And Mr. Lee has begun to work with a recovery coach here at OCI and plans to continue working with CCAR upon his release back in the community. Ma'am, yes. I do believe after serving as much time as I did being incarcerated, I only went back to what I knew how to do fast to make money, and that was dealing with the cars. I jumped into it. I let that sidetrack me, and I didn't follow my sobriety plan. And it took control. And I got ahead of myself, and I drank. And I had a special person in my life, and they warned me and told me, and I didn't see it, but I seen the signs. And I really couldn't tell on myself. And I'm ashamed today because that day I looked back at that car as she was leaving and I wanted to stop and say, I'm not doing good. And ma'am, that was my addiction. And I left and I drank. Ma'am, I'm glad that nobody got hurt in that car accident. I thank God for that. But I do see how things work, which is why I got certified to be a recovery coach. And I'm going to do that. Whether I stay here till my end of parole sentence, no matter how long it takes, I know what my calling is, what I need to do. So I can only blame myself. And I'm sorry that I'm back here in front of you. I'm sorry that my son has to go another however long he has to without his dad. And I hope that he makes good choices. I tried on my own and failed. I can't do it on my own. I need to be around people that are sick like I am, like I was. I can't do this on my own. I have some people that are showing me things about me, and I'm learning things about me, and it hurts every day. I feel alone. I'm tired of being ripped apart. I'm tired of coming back to these walls. I didn't ask for things that happened to me when I was a kid, but I can't use that as an excuse because I'm old enough to know right from wrong. And sitting here in front of you with a sober mind, I'm okay to let things go today and not let my past predict my future anymore. So I just want to say I apologize. I'm grateful that nobody's injured. And thank you for your time.
Thank you.
Thank you very much, Mr. Lee.
I appreciate your statements.
Sorry.
So I have noted everything that was stated today. I've listened to all the testimony today. I have reviewed all the evidence provided by the state. I will put on the record, you were only in the community for about 9.5 months before getting these new charges. You are on special parole until 2029. So you do have a long period of supervision to follow. This is your third offense for illegal operation of motor vehicle. So you were extremely lucky that no one else was killed, and you've been through this before numerous times. And it's unfortunate that it brings you where you are today. This is your first violation on this period of parole. You did receive 4 misconducts since your release in November of 23. Based on, as I previously stated before, you do have a mandatory minimum that is 9/12/25. Your EOS date on this sentence is 3/7/26 as of today.
Yes, ma'am.
So based on all the information that I have, I do recommend that parole be revoked to be re-paroled for March 7th of 2026. This is approximately 18-month period confinement as a sanction. This is your EOS date on that new conviction. I do recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, operation of a motor vehicle, behavior management program for domestic violence, no contact with your victim, TL, and mental health evaluation treatment as deemed necessary. My findings are going to the parole board on April 17th. So the board can either agree with me, they can let you out as soon as 9/12/25. That is the earliest they can let you out. They can also max you out because they do have the ability to revoke special parole. So you're going to know that, well, you will know that day. You'll get it in writing from us about a week after the date of 4/17. You'll get the board's decision as well as your conditions. You can also speak to the attorney
Yes, Mr. Lee, if you would like to call my office, I would say that, well, I think we're out that Friday. If you want to call the following Monday, I can let you know what the board decides. I won't physically be here on the 17th, but if you want to call my office, we can let you know. Somebody from my office can let you know what the board decides, okay?
Just so you know, if they do want to hold you in longer, which is an option, you would have a supplemental hearing. And they would call you back and talk to you about that if they did want to do that.
And I would be with you at that hearing as well. So if that is, what happens, we should know that on the 17th, okay?
So let me get this straight. You're recommending that I finish the whole 18 months. That's what you're saying?
Yes. Her recommendation is free parole on 3/7/26, which is an 18-month sanction, okay? So the board has the final say. They will let us know their decision on the 17th, okay?
You understand?
I understand.
Okay.
All right. Thank you very much, Mr. Lee. I will set up a legal call with you for that day.
Thank you. Have a good day, everybody.
Have a good day. You're all set. Wish you the best of luck, sir.
Yeah. Thank you. Yeah, thank you. All right. Have a good day.